As your participants know that we are going to discuss today charges in criminal trials, framing of charges, discharge of accused persons. Various facets of this subject will be covered by us in our discussions today. The word charge, what does it mean? What is the purpose behind framing charge or charges against accused in a criminal trial? When an offense is investigated by the police, a voluminous report, what is called charge sheet, is submitted to the court. In some cases, the charge sheet runs into thousands of pages, hundreds of pages. Then question arises whether an accused would be called upon to deny and defend himself against all the material contained in the charge sheet running into thousands of pages, hundreds of pages. Answer is no, because it is the minimum accusation, where accusation contained in the charge sheet, contained in the police diary, what is called a police report, which constitute the penal sections, penal offenses. An accused is supposed to defend himself against this penal allegation, criminal allegation labeled against him, that constitutes the penal section. Penal offense defined in the penal section. It is not each and every accusation, each and every statement of a witness or any other material document that has been made part of police report, which an accused has to defend himself against such voluminous material placed before the court. In short, a charge is that allegation which constitutes offense against which the accused is supposed to defend himself. By framing a charge, by labeling a charge, an accused is precisely made aware of the accusation which the investigating agency has labeled against him, and against which allegation he will be given opportunity to defend himself, and which allegation the prosecution will be called upon to prove against him. It's a precise statement. A charge is framed few lines, few words to make the accused familiar with the real accusation against him, so that the accused may come to know that this is the allegation constituting the offense which the prosecution will prove against him during trial, and which he will disprove, or he will produce his defense evidence to disprove, to falsify the allegations made against him by the prosecution. In old CrPC, that was applicable up to 30th June this year. The subject is started from section 211. Now in Bharati Nagarik Suraksha Sanghita, BNSS, which has come into force from July 1st, this 211 of the CrPC has now become 234. If you go to this BNSS of 2023, in the very beginning, there is a table. In this table, the sections of CrPC have been given on one side, and in front of them, the equivalent section, which is now there in the BNSS, they have been given. In old CrPC, the sections which were there in relation to the charges, they started from section 211. Now it starts in BNSS from 234 onward. You know, there is one very important section in BNSS, that 531. In what cases the CrPC will continue to apply, and in what cases this new law, that is BNSS, will now apply. It has been provided in section 531 of the BNSS. Section 531 says all those inquiries, trials, applications, investigations which are pending before July 1st, they will be covered by the CrPC. CrPC will apply to them. Those applications, trials, inquiries, investigations which came into existence for the first time on July 1st, they will be covered by BNSS. So this is the section which clarifies where CrPC will apply and where this new procedural law, what is called Bharati Nagarik Suraksha Samhita, BNSS will apply. I will take you through this subject with the help of leading Supreme Court decisions. Because you know, the law which you have, if there are some students participating in this program, for them I am telling, otherwise the advocates who are practicing, they know there is no much problem with them. They are already familiar with the subject. But the law students who have just been taught in their classrooms by law teachers, they have only theoretical understanding of the subject. But when this theoretical law comes into practice, then it applies quite differently. In our judicial system, the interpretations of laws made by high courts and by the Supreme Court, they are the final laws. Interpreted laws by Court of Records, Supreme Court and High Court, they are the ultimate laws, not the bare provisions contained in the bare acts. In order to correctly, precisely understand this subject like any other subject of law, we will, as usual, take help of the Supreme Court decisions if they are available. And if they are not available, then of course, we will take the help of leading judgments of various high courts. But fortunately, almost all important aspects of law, Supreme Court rulings are available, judgments are available. It will be only very rare when I will take you through some judgment of any high court. Otherwise, we'll take you through only the judgments of the Supreme Court, and that too the leading judgments, prominent judgments. Before taking you through this subject point by point, I will draw your attention to a website of mine, lawhelpline.in. Those who are participating in this program, they may open it on their laptop, computer, or even on mobile. Small letters without space. Lawhelpline.in. The subject for our discussion today, charges in criminal trials. This subject is available on this website, lawhelpline.in. Those who can open this website, lawhelpline.in, please open it so that when I am pointing out something from here, you may be able to see it on your screen of your laptop, your computer, your mobile. I think by now many of you have opened. There are hundreds of subjects on this website. Yours is charges in criminal trials. Name of the subject is charges in criminal trials. In old CrPC, outgone CrPC, the law regarding charges in criminal trials were sections 211 to 224 in CrPC. These are the sections. Now this 211 has become 234 and other sections have been arranged thereafter. Now this chapter charges starts in BNSS from section 234. In CrPC, the relevant sections were 211, starting from 211 up to 224. Then section 226, 227, 228, these are the sections meant for session judges, where a session judge used to either discharge the accused or frame a charge against him. Section 226, 227, 228. For my states in CrPC, these sections were 239 to 40. Discharge of accused or framing of charges. Then there is another section in the outgone CrPC, section 464, 464. If there is any omission, irregularity, defect in the charge, then this defect is curable. If it does not prejudicially affect the accused, then mere defect, irregularity in framing of the charge is immaterial. This is what section 464 of the CrPC declared. Then there are special statutes, special acts, like you can say Arms Act, NDPS Act, Unlawful Activities Prevention Act, Money Laundering Act. There are dozens of special acts which contain penal provisions. Then they are also relevant for purposes of framing of charges. And above all, the major judicial pronouncements of the Supreme Court and High Courts. In short, these are the different laws which apply to the discharge of the accused or framing of the charges. by courts. What could be the object of framing of charge by the court? Supreme Court in 2014 in Chandra Prakash versus State of Rajasthan clarified the object of framing charge against an accused person in a criminal trial is to make him aware of what he is to be tried for by the court by clearly explaining to him the main facts sought to be established against him by the prosecution or the complainant so that he may have a full and fair chance to defend himself at the trial. The real accusation has to be explained, has to be made known to the accused in order to make him able to understand the accusation for which he is to be tried by the court, to make him familiar, to make him know the accusation. This is the object, purpose of framing the charge. Just imagine if an accused doesn't know if for what he is going to be tried, it will be very difficult for him to defend himself. He will be in utter confusion, in utter ignorance. The primary object behind framing a charge against the accused is to let him know what are the accusations for which the court proposes to try him and what are the accusations against which he can defend himself. Number one, accusations should be brought to his knowledge. Number two, providing him opportunity to defend himself. These two things you can say are the objects which are achieved by framing a charge. There are a host of rulings. I just cited one, Chandra Prakash State of Rajasthan 2014 Supreme Court. I have given many Supreme Court rulings on this point. It's a point number 1B in my article under this chapter, charges in criminal trials. I think all the participants have opened this website, lawhelpline.in, and they have reached this subject that is there on this website, charges in criminal trials. If you open this subject, this file, you will find what I just told you. The object of charges, I'm again repeating, is to make the accused to know the accusations against him and to defend himself. Then moving to next point, contents of charges. What are the contents which a charge is required to mention, to contain? What should be mentioned in a charge? In old CrPC, section 211, 212, 213 were on this point. Now, these sections start from 234, 235, 236. These are the new sections which replaced the CrPC sections 211, 212, 213. Contents of charge. I'm now explaining to you the contents of charges. So, as these sections provide, now in BNSS 234, 235, 236, name and designation of the judge or magistrate framing the charge, name of the accused against whom the charge has been framed, charge is going to be framed, date, time, and place of occurrence, particulars of the person against whom or the property in respect of which the offense was committed, ingredients of the offense committed with its penal section, name of the offense and the manner of its commission. In brief, direction to the accused to be tried on the charge framed by the court, signature of the judge or magistrate framing the charge, narration in brief that the charge has been read over and explained to the accused, expression of the accused whether he confesses to the offense or claims to be tried. In all, these are 10 items which a charge is supposed to contain. Where are these things provided? They are provided in old CrPC in section 211, 212, 213. What are the equivalent sections now in BNSS? They are 234, 235, 236. Those who have opened my website, they can see it very easily under this caption. Charges in criminal trials. In a charge, these 10 things must find place. Then I'm moving to another point, 3A. only the material produced by the investigating agency can be considered by court for framing of charges. The question arises whether an accused has the right to produce any defense material, any evidence in his defense of the charge, or for purposes of discharging him. Answer is no. A charge has either to be framed on the basis of the material contained in the police report, in the charge sheet, or not at all. If there is no material convincing the court to frame a charge against an accused contained in the case diary, you know what is case diary? The police report submitted by the investigating agency under section 173(2) CrPC. In BNSS, there is equivalent different section now. In CrPC, it was section 173, subsection 2, whereunder a police report is submitted or was submitted by the investigating agency after completion of the investigation. The same is the procedure even in BNSS, in new section, which replaced 173(2). It is the material collected by the investigating agency in its police report that is used by courts for framing of charges. An accused has no right to produce any evidence in his defense against framing of charge or against or in support of discharge. Only material which is considered by courts is the material collected by police and submitted to the court in the form of charge sheet. You know what's charge sheet or final report? They are nowhere mentioned in the CrPC, but it means a police report submitted to the court under section 172 CrPC after completion of the investigation. Both final report and charge sheet are said to be the same. Whether it is final report or charge sheet, in legal parlance, they are police report submitted to the court after completion of investigation. It is that material which police had collected that is used by the courts, not any defense evidence produced by the accused. An accused has no right to produce any evidence showing to the court that he is innocent, no charge can be framed against him. There is no such law. Law is that either for framing the charge or for discharging the accused, only the material, the evidence collected by IO, investigating officer, would be used. There are cases on this point. If you have opened my website, Charges in Criminal Trials, you can see there is a case, MV Sivaling Murthy versus CBI 2020, volume 268. There are a host of cases of the Supreme Court wherein this principle has been laid down. It is the material collected by the investigating agency alone that has to be used by the court for framing of the charge. And when an application has been moved by the accused, discharging him with the prayer to discharge him, again, accused cannot produce any evidence. He has to show to the court that no charge is made out of the evidence collected. In both events, either framing of charge or in the event of discharge, an accused has to show to the court only the material contained in the police report. He cannot produce any evidence from his side in his defense. Covered 2-3 points by now. If you have any doubt up to this stage, please put your questions. After dealing with your questions, I will proceed further. Questions, if any. These points which have been covered so far.
On the points that have been covered, only on these points, or you can ask a query for now participants. Sir, a participant is asking, can the court amend a charge?
These are the points which I will be covering during this session. We'll take this issue later on. I just want to take them point by point.
Yes, sir.
Charge can be altered any time. In CrPC, there was a section 216 which permitted the court to amend, modify the charge any time during the trial. I will discuss that point later on. The relevant section in CrPC was 216. Now there is another section equivalent to it. You can see in the table given in the beginning of the BNSS. The new section which replaced this 216 of the CrPC is there. Whenever you want to know what is the exact section now in BNSS or the section in the CrPC, you must see that table given in the beginning of the BNSS. It's very difficult to remember all the hundreds sections in one. Gradually, everybody will come to remember all these things always will be there in memory. But you know, only from July 1st, this BNSS has been introduced to everybody, whether he is a magistrate, he is a judge, lawyer, or anybody else. Everybody is familiar with the sections in the CrPC. It will take a year or two to remember the new sections which are exactly used for the sections in the CrPC, now in the BNSS. So for 216, there is a different section, and if I am to point out, then it is 239. I'm showing you, if you can see, I have opened the table given in the beginning of the BNSS for 216. It is now 238. No, 239. In BNSS, it is section 239. It empowers the court to alter the charge anytime during the trial. I will discuss this point when I reach there. Ingredients of offenses should be seen in the material produced before the court for framing of charges. I had earlier pointed out that a charge sheet submitted to the court by the investigating agency runs into hundreds of pages, thousands of pages. Many of you must have seen the charges framed by the courts. A charge appears only in few lines, 3 lines, 4 lines, 6, maximum 8 to 10 lines. A charge doesn't run into pages and pages. Starting from 2-3 lines up to 10-12 lines, a charge concludes, ends, because it is the gist of the accusation, exact essence, gist of all the accusations contained in the police report, which is used for framing the charge. When a court frames the charges or a single charge against the accused, then the duty of the court is to see whether the ingredients of the particular offense for which the accused is being charged are available in the case diary, in the evidence collected by the IO. If out of the evidence collected by the IO, the ingredients of the particular offense are not met, are not found, then charge cannot be framed. What is the duty of the court while framing the charge? To see in the case diary. I'm again clarifying you to what does this frame mean, this phrase mean. Case diary means that police report, charge sheet, you can use any word for it. Charge sheet, case diary, police report. These are similar words. You can use any of them. When I say case diary, you should know it as police report or charge sheet. Duty of the court is to see whether the ingredients of the offense are available for framing the charge. Where from the court will see? Court will see it into the evidence collected by the investigating agency, which is available in the form of case diary or police report before the court. Ingredients of the offense. You know, suppose a magistrate has to frame a charge against an accused for the offense of theft, 379. A charge by magistrate against an accused has to be framed for the offense under section 379 of the IPC, for which there is a new penal section in the Bharatiya Nyaya Sanghita. You know, IPC is now called BNS, Bharatiya Nyaya Sanghita. So 379 has been replaced by a new section. Go to the table, you will find it. Table has been given in the beginning of the BNS, and you will find the exact section which is now to be used from July 1st for old 379 of the IPC. So just tell me, somebody from among the participants, please tell what are the ingredients of an offense of theft in IPC. Section 378 used to define the offense of theft, and the penal section was the next section 379. Tell me what are the ingredients of, anyone who knows what are the offense of What are the ingredients of the offense of theft? Movable property, removal of such movable property by accused, removal with dishonest intention, removal without consent of the owner. These are certain ingredients which constitute an offense of. There must be some property, it must be removed, there must be removal, taking away. This taking away or removal must be without the consent of the owner of the property, and there should be dishonest intention. Anybody who dishonestly removes some movable property of other without his consent is called to have committed the offense of theft. So, removal, movable property, removal, dishonest intention without consent. If these ingredients are available, so when, as my state, you are framing a charge against an accused for the offense of theft under section 379 of the IPC, you should see whether the IO has been able to collect evidence which reflects or which shows these ingredients into the evidence. If the statement recorded by the IO under section 161 of the CrPC says that the witness or the person whose movable property has been stolen, if he has made a statement to the police that accused had stolen his purse without his consent and had taken away with dishonest intention, if this statement is sufficient for framing a charge against the accused for the offense of theft under section 379, because ingredients of the offense are appearing in the statement of the witness, which he had made to the investigating officer during investigation under section 161 CrPC, for which now there is a different section in the BNSS. 161 is now a different section in the BNSS. I'm just referring here to you the sections of the CrPC. If it is an offense which was committed on July 1st or afterwards, then there is a new section for this 161 in your BNSS. This is what is done by the courts. The ingredients of the offenses are seen in the evidence collected by the investigating officer. If the ingredients are available in the evidence, charge can be framed. Then I am taking you to next point, 3C. If you have opened the article of mine, captioned charges in criminal trials, so then this is para 3C. Charge can be framed on the basis of FIR, complaint or accompanying document or material brought on record during trial. It's not mere statement of the witnesses or the victim of the offense which is used for framing the charge. Even the FIR, because you know FIR contains accusations against the accused, and if it is a complaint case, then in complaints the accusations are recorded or stated, and if any document has been provided by the informant, by the complainant to the police during the course of investigation, then that document can also be used for framing the charge. What would be seen out of these documents, whether it is FIR, complaint, document, or statement of witnesses, the ingredients, please always keep in your mind. If when a court is going to frame a charge against an accused, then whatever material has been placed before the court by the police or by the complainant, if it is a complaint case, the duty of the court is to see whether in the material placed before it, ingredients of particular offenses are available. If they are available in the evidence, charge has to be framed. I have cited Supreme Court cases in support of this view. If you have opened the website at this file, you can see. And then come to para 4, point 4 of my article. Name of the article, I am again and again repeating. Charges in criminal trials. Point 4 of this article says, production of document or material by the accused at the time of framing of charge or discharge not permissible. An accused has no right to produce any evidence on his own in his defense against framing of charge. I had already discussed this point elaborately to you earlier and need not to repeat it again. An accused has no right to produce any material, either against framing of charge or requesting the court to discharge him. An accused can point out only the material collected by the IO, and the prosecution also can rely upon only that material for framing of the charge, which is there in the case diary or in the police report submitted by the police after framing of the charge. Then come to para 5, point 5 of my article. Name of the article, I am again and again repeating. Charges in criminal trials. Point 4 of this article says, production of document or material by the accused at the time of framing of charge or discharge not permissible. An accused has no right to produce any evidence on his own in his defense against framing of charge. Either against framing of charge or requesting the court to discharge him. An accused can point out only the material collected by the IO, and the prosecution also can rely upon only that material for framing of the charge, which is there in the case diary or in the police report submitted by the police after completion of the investigation. Both the parties, prosecution and accused, they can only use the case diary or the police report. Even prosecution doesn't have any right to produce any additional evidence at the stage of framing of the charges. Neither prosecution nor accused have any right to produce any additional evidence than the one collected by the IO. The only evidence that can be looked into, that can be considered by the court at the stage of framing or discharging the accused, framing the charge or discharging the accused, is the case diary, material in the case diary, in the police report. There is no liberty, no right to the prosecution or to the defense. They are bound to use only the case diary, the police report. Court also doesn't have the power to use any other material which is not part of the police report, the case diary. Court doesn't have power, accused doesn't have right, prosecution doesn't have the right to use any extraneous material which was not collected by the IO during the course of investigation. Only the material contained in the police report has to be used by the court, by the accused, by the prosecution. Clear? Now I am proceeding to point number 5. Power of court to summon documents under section 91 CrPC at the stage of framing of charges not permissible. You know, in CrPC there was a section 91 empowers the court to summon any document, to summon any bid document to be produced before the court for using the same in the judicial proceedings. At the stage of framing of the charge, court has no power to order any person to produce any documentary evidence under section 91 for purposes of framing of the charge against the accused or for purposes of discharging the accused, because you know it is only that evidence which the IO had collected can be used. Section 91 of the CrPC has no relevance at the stage of framing of the charge or discharging of the accused. This is section 91 of the CrPC. For section 91, the relevant section now is section 94. Section 91 of CrPC has now become 94 in the BNSS. The same provision is there. Only the section has been displaced from here to there. Section 91 has now become section 94. I'm again pointing out to you, when you refer to any section of the CrPC, you go to the table given in the beginning of the Bharatiya Nagarik Suraksha Samhita and see what is the new section in the BNSS for the section mentioned in the CrPC. For 91, it is now 94. What is the extent of inquiry at the stage of framing of the charge or discharge of the accused? I'm using two terms, framing of charge, other discharge of accused. You are familiar with section 239, 240 in the CrPC. Warrant trial. You know, in CrPC, there are three types of trials: warrant trial, summons trial, summary trial. So the same are here also in BNSS. Under 239, the accused is discharged. Magistrate would discharge the accused. And if he is not discharged, only then the charge would be framed by the magistrate under section 240. So 239 empowers the magistrate to discharge the accused. 240 empowers the magistrate to frame the charge. A charge is framed only when the accused cannot be discharged. Same is the position in CrPC for session judges. Section 227, 228, 227, 228. If the accused cannot be discharged under section 227, only then a session judge can frame a charge against the accused under section 228. And when accused would be discharged, when out of the evidence produced before the court, ingredients of the offences are not made out, what is called in legal parlance, when no prima facie case is made out against the accused. It means when the ingredients of any offence are not available in the evidence, no offence is constituted out of the evidence produced by police, then accused will be discharged. And if ingredients are available in the evidence collected by police, then charge would be framed. Firstly, the court would see whether accused can be discharged. If accused cannot be discharged on the basis of evidence placed before court, then the charge will be framed. You know, in a warrant trial before magistrate, it is section, these are the sections 239 to 40, charge and discharge. Discharge and charge. First discharge, then charge. If accused is not discharged, then charge would be framed. Same is the position before the session judge. Section 227, 228. If the accused cannot be discharged under 227, then charge would be framed under section 228. These are the provisions for which there are now new sections in the BNSS. What is the role of the court, whether it is court of magistrate or court of sessions or any other court, at the stage of framing of the charge? Extent of inquiry, what amount of evidence is needed at the stage of framing of the charge or discharging of the accused. Supreme Court says no in-depth assessment of material has to be made at the stage of framing of the charge. Framing of charge cannot be equated with a mini trial. When a charge is framed, there is no need to decide the culpability of the accused or innocence of the accused. At the stage of framing of the charge, the guilt is not decided finally. Only summarily, cursorily, and prima facie, court looks at the evidence produced before it in the form of police report by the investigating officer, investigating agency. And if the ingredients of the offense are available, charge has to be framed. What is looked at the stage of framing of the charge? The ingredients in the evidence, not the finding, not the conclusion of guilt or innocence of the accused. Please try to understand. At the stage of framing of the charge, guilt or innocence of the accused is not decided. Guilt or innocence is not decided, not seen. Then what is seen? Whether ingredients of the offenses are available in the case diary. This is seen. I think you are able to understand the difference. No guilt, no innocence is decided. Merely because charge has been framed, it doesn't mean the accused is guilty of that charge, that offense. No, because ingredients were there in the allegations in the evidence produced before court. Therefore, court framed the charge. Whether the accused is guilty or not guilty, it has to be decided during the trial on the basis of evidence that would be led by the prosecution and or the defense by the accused. The stage of framing of charge, question of guilt or innocence is wholly irrelevant. Standard of scrutiny of evidence at the stage of framing of charge. 2020 Supreme Court, Bhavna Bai versus Ghanshyam. 2020, two Supreme Court cases, 217. There are other cases also where Supreme Court says whether it is the stage for discharge or framing of charge by session judge under section 227 or 228 or discharge or framing of charge by magistrate under section 239 or 240 of the CrPC. Only the ingredients prima facie case has to be seen out of the case diary, out of the police report submitted to the court. The court doesn't decide or does not venture to go into the inquiry to make an observation whether the accused is guilty or innocent. This is not the role of the court at the stage of the charge. So no depth inquiry is made. Simple reading of the case diary is done. Statement of the witnesses, documents, whatever evidence has been collected by the IU and submitted to the court, that is only cursorily seen. And if prima facie case is made out, that means if the ingredient of the offences are available, then charges are framed. But no observation can be made the accused is guilty or accused is innocent. If the accused is being discharged, it doesn't mean the court will declare him to be innocent. What would be the observation? The ingredients of the offences are not available in the evidence produced by the IO. No prima facie case is made out against the accused. Hence, there is no material for framing the charge against him. He deserves to be discharged. And if the ingredients are available in the evidence, then court will record its observation. Yes, out of the evidence produced by the investigating agency through police report, ingredients of the offences are found to be available. Hence, there is a prima facie case against the accused for framing the charge of such and such penal section, and then court will frame the charge of that section, that penal section. But the court will not declare the because there is a prima facie case or ingredients are available in the evidence, it shows that the accused is guilty. No, word innocent or guilty cannot be used at the stage of discharge or charge of the accused. Again and again pointing out these things just to make you clear in your mind what is the scope of inquiry or scrutiny of the evidence by the court at the stage of discharge or framing of the charge. If you have any query with regard to this issue, please point out, you seek clarification. If you have any doubt with regard to the extent of inquiry and scrutiny of the evidence to be made by the court at the stage of discharge or charge.
Sir, a participant wants to know what is the difference between an inquiry and investigation. Because after a charge is during framing a charge, the police conducts investigation.
Investigation is conducted by police. Inquiry is conducted by court. What is difference between inquiry and trial before the court? You know, a trial begins with the framing of charges. Framing of charge and onward proceedings, they are called trial. If no charge is framed, then trial doesn't commence. In a civil case, when the court proceeds to apply its mind to the whole of the case, all the material available on record, and that stage in a civil suit arrives under Article 14 of the CPC when the issues are framed. So with the framing of issues in a civil suit, trial starts. Same is the position here. With the framing of the charge, trial starts. If no charge is framed, it means the accused would stand discharged. And when the accused has been discharged, obviously there would be no trial. The framing of charge, your trial commences. And what is inquiry? Before framing of the charge, before commencement of the trial, whatever proceeding is undertaken by the court, that is inquiry. You know, after completing the investigation, police submits police report under section 173 to CrPC, for which there is now a new section in your this new BNSS, and that section is R173.2. I'm pointing it out to you. It is 193 in BNSS. It is now 193, section 193. In CrPC, it is 173. So when charge sheet is produced, charge sheet means that police report after completion of investigation. Then first step is the first step or proceeding which is undertaken by the court is the court takes cognizance of the offences. What is the nature of this proceeding? Nature is inquiry. When the court proceeds to take cognizance of the offence upon police report, this proceeding is called inquiry. It is not trial, because as I pointed out, a trial commences with the framing of the charges. If the charge is not framed, accused is discharged, then no trial takes place. Taking cognizance or providing copies of the police report under section 207 of the CrPC, under BNSS there is another section for this. All these are parts of inquiry. A showing process after taking the cognizance to the accused to appear is part of inquiry. The inquiry covers all those proceedings which take place with the submission of the charge sheet to the court and before the commencement of the trial. Once the charges are framed, then the proceedings are called trial. And before that, the proceedings are called inquiry. Investigation doesn't take place in the court. Who investigates the offences? The police. In ordinary parlance, you can say कि police are inquiring, police जांच कर रही है, police are inquiring. But in legal parlance, you will say the police are investigating. The investigation takes place on the part of the police, and inquiry and trial relate to the proceedings of the court. You understood?
Yes, sir.
Then let us proceed forward. I am now discussing para or point number 6D of this compilation of mine. I'm again pointing out the name of the website, helpline.in, and the name of this file, charges in criminal trials. I have now taken up point number 6D. Truth and sufficiency of evidence at the stage of framing of charge is not to be tested. If you have seen the police report submitted by police after completion of trial or completion of investigation, you must have seen in the police report there is application that was presented to the SHO for registration of FIR. Then that FIR which has been registered by the police on the format provided in the police manual. Then there is a statement of the informant recorded by the investigating officer under section 161 of the CrPC. I'm referring this section from CrPC. For this 161, there is a different section. You need to go to the table in the beginning. For 161, it is section 180. In BNSS, it is 180. I'm showing it to you from the table of sections given in the beginning of the BNSS. Whenever you want to know which is the new section in BNSS for the old section in the CrPC, you need to go to the table given in the beginning of the BNSS. So I was pointing out to you the investigating officer submits these things to the court. Application, if any, presented to the SHO for registration of FIR, then the FIR that was registered by the police, then a statement of the informant recorded under section 161 CrPC, then the statement of witnesses recorded by the IO under section 161 or by the magistrate under section 164 of the CrPC, injury report, if any, medical legal report, if any, or any document, any other material which the police has collected during the course of investigation. These entire materials are collectively called police report, case diary, charge sheet, and once submitted, then this is the material which the court looks into. How will court treat the statement of the informant made to the IO under section 161? Whether court can disbelieve? Question of disbelieving doesn't arise at the stage of framing of the charge. Whatever statement has been made by the informant and his witnesses during the investigation to the investigating officer, they will be taken to be true at their face value. Please mind, note it. Nothing would be disbelieved made in the application presented to the SHO for registration of FIR. The statement made investigating officer during investigation, the statements made by the witnesses to the investigating officer during investigation would be taken to be true. It will not be treated to be untrue. At this stage, at the stage of framing of the charge, the statements are not disbelieved, not declared to be untrue. Whatever the informant or witnesses have stated to the police, it will be taken to be true at their face value. Nothing is disbelieved at this stage. Court will not record an observation at the stage of framing of the charge that, in the opinion of the court, the statement of the witnesses appears to be false. No, if the court has made any observation like that in its order would be set aside by the Superior Court revision or under section 482 by the High Court or by the session judge if a revision is filed before the session judge against the order of the magistrate. Because whatever material is there, whatever statement it is there in the police report collected by the IO, it will be taken at its face value. If any questions, please put on it. Contradictions, if two witnesses have made contradictory statement to each other during the course of investigation, suppose the investigating officer recorded statement of an informant injured. He supported the prosecution story. Yes, XYZ accused had assaulted me and had caused me injuries by stick, by knife. Other witnesses say, no, they made the statement to the police, no, I had not seen. XYZ accused had not caused him any injury. Somebody else had caused him injury. So there are these opposite statements. This PW1 is saying, prosecution witness one is saying something, others are saying quite contrary thing. What will be done now? A single statement by single witness is sufficient for framing the charge. This contradictory statement by other witnesses will not be considered. That has no relevance. If the ingredients of the offense are available out of the evidence of a single witness, then charge would be framed, irrespective of the fact that the other witnesses did not support this witness. No, supporting or not supporting, contradicting or not contradicting is not relevant at the stage of framing of the charge. What has to be seen? Whether the ingredients are available in any evidence brought on record. 10 witnesses are there. 9 are saying no, the story is false. FIR is false. Accused have wrongly been made accused, but one witness is saying no, I was present on the spot. I had seen the accused XYZ assaulting the injured, and they had beaten him with a stick, and I had seen them beating the injured X. Then all these people will be tried. Charge would be framed, because at the stage of framing of the charge, support from other witnesses, corroboration from other witnesses, or contradictory statements of witnesses are not relevant. If you are a magistrate, you are a session judge, your duty is to see whether ingredients of the offense are available in any piece of evidence, in any statement of even a single witness. If the ingredients are available, charge has to be framed despite the fact that the other witnesses did not support. Yes, please, question, because these are most controversial, confusing facets of this subject, which even my states get confused many a times, because very fanciful arguments are advanced at the bar to the courts at the stage of framing of the charge. Framing of charge is the rule. Discharge is exception. Is it written somewhere in the CrPC or in the new BNSS? No, these laws do come from the judgments of the Supreme Court. The summary of all the law, all the judgments of the Supreme Court is that if the ingredients of the offences are available in any evidence on record, then a prima facie case will be deemed to be made out and charge would be framed. Charge would only be not framed when ingredients are not available in any single evidence. There is no evidence at all showing ingredients of offense. Then of course, accused would be discharged. Any questions, please?
Participants, any queries?
अरे वकील लोग तो जानते हैं ये विद्यार्थी लॉ वाले क्या कर रहे हैं, वो क्यों नहीं पूछ रहे हैं? या तो सब पढ़ डाले हैं या संकोच कर रहे हैं। ये वो चीजें हैं जो क्लासरूम में नहीं पढ़ाई जा रही आपको, क्योंकि वहां तो वेयर प्रोविजंस सेक्शन में जो है पढ़ा दिया। आई एम टेकिंग यू थ्रू द लीडिंग सुप्रीम कोर्ट जजमेंट्स एंड दैट टू द लेटेस्ट वंस।
Sir, if the statement of punch witness is contradictory to the statement of the complainant, so can this be a ground for discharge?
No, contradictory statement will not be considered. If a single witness says the accused had assaulted him, or he had seen the accused assaulting the victim, the injured, charge would be framed, despite the fact that many other witnesses had made contrary statements, falsifying the claim of this witness. Very little evidence is required. If a single witness says, suppose there are 5 witnesses, 4 say no such incident took place, but a single witness says no incident had taken place, I had seen the accused person assaulting the injured, charge would be framed. The contrary statements made by 4 witnesses will be kept aside. A single statement made by this single witness is sufficient for framing the charge. Understood?
Okay, sir. Sir, is a case diary same as a police charge sheet report?
It doesn't make difference. If after completion investigation, police submits a charge sheet and there is material, there is evidence in that charge sheet disclosing the ingredients of the offense, charge has to be framed. What has to be seen? The evidence regarding ingredients of the offense. If there is no evidence in the case diary, in the charge sheet, in the police report, constituting the prima facie case, means disclosing the ingredients of the offense, charge cannot be framed. Taking you to point
So
number
there's a
6.
participant raising hand. Can we take the question?
Yes, why not?
Okay, sir.
I'm
Unmuting the participant.
more than willing if they
Good afternoon, sir. I have a question. Yeah, like since we are talking about the electronic evidences, so just I would like to know, like in trial, whether it is a video conferencing or in FIR. Like nowadays, what I have read, whatever police is taking crime scenes, that has to be recorded. So just I wanted to know, wherever the electronic evidence interference is appearing in any stage of the evidence gathering, just I would like to know that.
Yes. every mode of electronic device is permissible, whether it is investigation, inquiry, or trial. In new BNSS, a complete scope, full scope has been given for using the scientific devices, electronic devices for investigation of the crime, or even submitting the charge sheet to the court through electronic mode, through email, etc. Examining the witnesses, recording their deposition, everything can be done by the court by using the electronic device in electronic mode. Everything is now permissible under our BNSS. You know, Evidence Act, when the Information Technology Act 2000 was passed by the Parliament, then many sections were added in the Evidence Act in the year 2002, and all the electronic evidences have now been incorporated within the meaning of word evidence. This electronic evidence, whatever may be the mode, is very much admissible in evidence. Earlier, you know, the evidence used statement of witnesses, evidence. Now, in the definition of documentary evidence, electronic evidence has also been included. Now, electronic evidence has full meaning, full acceptance, fully admissible in new laws, both in Evidence Act and all such electronic modes can be applied under the BNSS by the police for investigation of the offense, or even by the court for purposes of inquiry or trial. Then, if any evidence has been, suppose CCTV, in CCTV camera, certain visuals are recorded, some incident has been recorded, or somebody has recorded the manner of occurrence of the incident by using his mobile phone. This evidence is admissible. This electronic evidence that was recorded through mobile, through it is very much evidence that can be used.
Ma'am, disturbance हो रहा है. Sorry, sir. Please carry on.
You got your answer.
Shali, ma'am.
Truth.
Sir, yes, sir. Yes, sir. Yes, sir. I have one. Hello. Thank you. Thank you very much, sir. I have.
Then yes.
I have one more question. Like, if any crime is happened on 30th of June 2024, when there was this new act was applicable, and that's supposed to be filed on 1st of July, then which act will be applicable in this scenario?
CrPC will apply. Word pending occurs under section 531 of the CrPC.
Filing is happening on 1st.
No, it means filing means the moment a proceeding, a case is filed before the court, then it comes to pend. Word pending has been used. Suppose on July you made an application to the court. So your application came to be pending on July 1st before the court. It will be covered by BNSS. But if your application was already made to the court on June 30th, it means your application was pending before the court on 30th June. Then CrPC would apply.
Sir, just one more clarity I wanted. Like, if any murder happened, then the police investigation and everything was going on, it will not come to the court on 30th. It will come to the court on after some days, 7 days, 8 days. So in that
CrPC will apply.
Okay. Thank you, sir. Thank you.
But there is any doubt, please go through section 531 of the BNSS. But you must keep one thing in your mind. All those offences which were committed before July 1st means that on June 30 or prior to June 30, the penalty would be awardable against the accused. That was applicable under the old penal law. This Bharatiya Nyaya Sanhita will not cover that case. Suppose that if a penalty has been enhanced under the Bharatiya Nyaya Sanhita from July 1st, or the offence was committed on June 30th, in January, in February 2024, so what would be the penalty? Whether under this Bharatiya Nyaya Sanhita or under the IPC? The answer is the penalty that was provided in the old penal law, that is IPC, that would be awarded to the accused. Because when an offence is committed on July 1st or thereafter, only then Bharatiya Nyaya Sanhita penalty will be awarded. Otherwise, if the offence was committed before coming into force of the Bharatiya Nyaya Samhita on July 1st, then IPC penalty would be taken from IPC. If the offence was committed on July 1st or thereafter, then penalty would be taken from new penal law, Bharatiya Nyaya Samhita. But if it was committed before July 1st, on June 30 or prior to June 30, then the penalty would be taken from IPC. Law is that the penalty that was provided by law on the date of commission of the offence, that penalty is awarded to the accused. If subsequently the penal law is changed, it doesn't mean that the changed penal law will apply. No, date of offence is the relevant date for selecting the penalty. That penalty which was in force under the old law on the date of commission of the offence, that will apply. I think you have got clarity. If it is still not clear, then I may again make it clear.
So we can move ahead.
I'm taking you to point number 6D. Truth and sufficiency of evidence at the stage of framing of charge not to be tested. 2004 Supreme Court, 2008 Allahabad. These rulings say that quantum of evidence doesn't matter at the stage of framing of the charge. Nothing can be said to be untrue. No statement of any witness can be said to be untrue. What has to be seen at the stage of charge? Whether ingredient of offense in the statement of any witness, in any document, this is all that is seen. And nothing will be treated to be doubtful, untrue. किसी चीज को झूठ नहीं मानेंगे. जैसे विटनेस कह रहा है, जैसा डॉक्यूमेंट में लिखा है, उसको ट्रू मान के हम चार्ज लगा देंगे. इस स्टेज पर किसी भी चीज को झूठ नहीं मानेंगे. Everything will be presumed to be true. This is what 2004 Supreme Court says. Presumption of truth of material brought on record by prosecution at the stage of charge. 2019 Supreme Court, State versus J. Dorai Swami, AIR 2019 Supreme Court 1518. I think my website lawhelpline.in, and you have reached this subject, charges in criminal trials. And I am pointing out point number 6E. There is a presumption that whatever the witness has stated to the IU during investigation, that is true. There is a presumption at the stage of charges that whatever is contained in the document is true. Court will start with this presumption. Then 6F, contradictions in the statements of witnesses that the state of charge not to be seen. 2014 Allahabad and 2010 Supreme Court, Sajjan Kumar versus CBI 2010. No contradictory statement in the statement of the same witness or in the statements of two different witnesses has any relevance. Your duty as magistrate, as judge, is to see the ingredients. If they are available, so despite contradictory statements by the same very witness, charge would be framed. अरे मोटा मोटा ये समझ लो एक सरल तरीके से कि charge ही लगेगा. This charge is a very difficult situation. It is another matter that the liars argue the counsel engaged by the accused moves application seeking discharge. But in most of the cases, such applications are rejected because the law framing of charges is so much liberal. It leans in favor of framing of the charges. Discharge not an easy thing. Although there is no bar, if there is no ingredient, no prima facie case is made out, discharge will happen. But if a single witness has stated कि yes हमको मारा पीटा, तो ठीक है चार्ज लगेगा. ये नहीं होगा कि नहीं और विटनेसेस कह रहे हैं कि नहीं मारा पीटा. Understood? Then I take you point 7A. Charge has to be framed even on strong suspicion. Supreme Court in host of cases has said, and one such case is State NCT of Delhi versus Shiv Charan Bansal 2020, two Supreme Court cases 290. I am pointing it out to you from para number 7A of my compilation, and caption is charges in criminal trials. This 2020 of Supreme Court and host of other cases of the Supreme Court, they say even when no evidence constituting the ingredients of offense could be found by the IO, but the IO has expressed strong suspicion, and the witnesses whose statement he had recorded, those witnesses had expressed strong suspicion with regard to the involvement of the accused in the commission of the offense. A charge could be framed. So far, I was insisting the ingredients of the offense should be there in the evidence, then charge would be framed. Now, even on the basis of a strong suspicion expressed by the witness, by the victim of the offense, with regard to the involvement of the accused in the commission of the offense, a charge would be framed. What is then the scope for discharge of the accused? Whether court can be liberal in discharging the accused? Yes, please, participants. Bhai bolo. No.
Any participant?
A court would be quite reluctant in discharging the accused. कोर्ट आनाकानी करेगी डिस्चार्ज करने से, अनविलिंगनेस दिखाएगी, और डिस्चार्ज तब करेगी जब बिल्कुल इंग्रेडिएंट्स नहीं है किसी भी एविडेंस में, एंड विटनेसेस ने स्ट्रॉन्ग सस्पिशन भी नहीं एक्सप्रेस किया है अपने स्टेटमेंट्स में. ओनली देन अक्यूज्ड वुड बी डिस्चार्ज. Otherwise, court would be extremely reluctant in discharging an accused. Framing of charge is the normal practice. Charge you can say कि just an exception. कुछ क्लियर हुआ है विषय कि नहीं? हाँ भाई.
So participants बोल रहे yes, clear.
अब कोर्ट में जो वकील लोग जाएंगे बहस करने, तो जब डिस्चार्ज एप्लीकेशन मूव करें तो उनको ये क्या क्या देखना चाहिए कि क्या पूरी एविडेंस जो स्टेटमेंट या डॉक्यूमेंट वगैरह हैं उनमें कहीं इंग्रेडिएंट हैं कि नहीं हैं ऑफेंस के, हैं तो किस ऑफेंस के इंग्रेडिएंट्स, या इंग्रेडिएंट्स नहीं भी हैं तो विटनेसेस ने क्या कहा है कि हमको पक्का यकीन है कि यही मुलजिम है जिसने अपराध किया है. अगर इतना भी कहा है विटनेस ने या इन्फॉर्मेंट ने, पुलिस को बताया है, केस डायरी में रिकॉर्डेड, तो चार्ज फ्रेम होगा. जब स्ट्रॉन्ग सस्पिशन भी नहीं अक्यूज के इन्वॉल्वमेंट के बारे में बताया हो और जब इंग्रेडिएंट्स भी ना हो किसी एविडेंस, ऑफ कोर्स एप्लीकेशन रिक्वेस्ट फॉर डिस्चार्ज वुड बी अलाउड एंड अक्यूज वुड बी डिस्चार्ज्ड. अदरवाइज ऐसा तो होता भी नहीं है. कम से कम इन्फॉर्मेंट जो है जिसने FIR लिखाई वो तो सपोर्ट करता है स्टोरी को. दूसरे गवाह मुकर जाएं, they may turn hostile, they may not support the informant, but at least informant supports his version in the content in the application in the FIR. So that is sufficient for framing the charge. तो फिर डिस्चार्ज का स्कोप कितना रह जाता है भाई, बोलो? बहुत ज्यादा.
Very narrow.
Very narrow. Almost. अब ये तो नहीं, I should say कि no, there is no scope for discharge because there is no prohibition in law against discharge of the accused. But the scope for discharging showing reluctance against framing of charge is very minimal. ज्यादातर यही होगा कि चार्ज ही फ्रेम होगा. Charge can be framed even on the basis of confession of co-accused. If there are more than one accused persons and no evidence is, you could not collect any evidence showing their involvement or showing the ingredients of the offense, but the other co-accused confessed the commission of crime and said that A was also, another accused was also involved with him in committing the offense. So then on the basis of this confessional statement of the other co-accused, charge can be framed. Hearing of prosecution and accused before charge or discharge mandatory. You know, at the stage of framing of charge, an accused has got a right to be heard. He can even move application for discharge. Even without moving a formal application seeking discharge, he can verbally through his counsel or he himself can make submissions to the court that out of the material in the case diary in the police report, there is no ingredient available regarding commission of any offense and I deserve to be discharged. Court will have to pass an order considering his submissions. And if the court finds yes, accused is right in pointing out that there is no material in the case diary, court may discharge. Otherwise, the duty of the court is to frame the charge. So at the stage of discharge or framing of charge, an accused and the prosecution, public prosecutor, both have got a right to be heard. Both the parties have right to be heard. Prosecution who appears for the prosecution before the court, the public prosecutor appointed the government, and who appears for the accused, the lawyers, advocates representing the accused, engaged by the accused. And if no such lawyer is engaged, then the accused may himself plead his case. And if he says, yes, I am unable to plead my case on my own, then duty of the court is to provide him free of cost the services of some advocates out of the panel maintained in the district legal services authority. Out of that panel, he will be given free of cost the services of some advocate. So after hearing both the parties, only the court will discharge or frame the charge. They have got a right. Both the parties have got right to be heard. Passing of preliminary order before framing of charge not mandatory. 2001 Supreme Court, 2000 Supreme Court. This preliminary order before framing of charge. Suppose that before the charges are framed, accused moves an application stating therein that there is no material showing ingredients or a prima facie case for framing of charge. So obviously, the court will hear both the parties, the prosecution and the counsel for the accused, and will pass a reasoned order, a speaking order, either discharging the accused or in favor of framing of the charge. So this order is called preliminary order. Preliminary means before framing of the charge. But the Supreme Court says the passing of preliminary order is not always necessary. If the court has outright framed the charges, then it means the court was satisfied with regard to the fact that a prima facie case did exist for framing of the charge. Impliedly, it will be presumed with the framing of charge that a prima facie case was there in support of. It's not always necessary for court to pass any preliminary order before framing the charges. If the charges are outright framed, a presumption is attached to the fact that the court was satisfied that a prima facie case. I'm taking you to point number 9A, discharge of accused. What are the sections in the CrPC for discharging the accused by the state? I'm pointing out section 239. In CrPC, it is section 239. And equivalent section to it is 262 in the BNSS. Now for 239 in a warrant trial by magistrate, it is section 262. If the magistrate, after considering the material case diary, finds that no prima facie case is made out or no ingredients of the offence are available, magistrate will discharge the accused. And if he finds ingredients are available in the evidence and a prima facie case is constituted, he will frame the charge under 240, and that section is 263 in BNSS. 262 discharge, 263 framing of charge. These are the new sections for sections 239 to 40 of the CrPC. For session judges, 227 is the section of discharge and 228 is the section for framing of charge. In BNSS, it is now section 250 and 251. For section 227 CrPC, in BNSS, it is now section 250. And for 228, 251, whenever you want to see which is the relevant section for the old section in CrPC, you need to consult the table which has been given in the beginning of the BNSS. Same is the law for magistrate and for the session judge. If out of material produced before it by the investigating agency, no ingredients of offences and no prima facie case is found to be made out, discharge will be ordered. And if prima facie case is made out, ingredients of the offence are available in any evidence collected by the IO and placed before the court, then charge would be there. Discharge, as I was earlier pointing out, is normally not done unless there is a genuine case, really a case where no prima facie case is made out and no ingredients are available. Normally, it doesn't happen in most of the cases. Charges are normally framed. Alteration, addition, or deletion of charges. Somebody had asked a question whether charges can be altered. In CrPC, the relevant section was 216. Answer is yes. Now I am dealing with this aspect. What is the new section now in BNSS for this 216 of the CrPC? The relevant section is 239. In BNSS, it is now section 239. And in CrPC, it was 216. 216 BNSS में क्या हो गई है? 239, 239. Court में frame a new charge. Court may modify the charge, alter the charge anytime during trial. If you want to see the cases on this point, then I'm pointing out Anant Prakash Sinha versus State of Haryana, 2016, 6 Supreme Court cases, 105. There are many other cases. I'm just citing one. Section 216 CrPC empowers the court to alter or add any charge at any time before the pronouncement of judgment. It can be done. When should court alter the charge? When previously was, but the court subsequently came to notice that the charge that was earlier framed was defective. In fact, some other charge ought to have been framed. Court can exercise its power under 216 or now under 239 of the BNSS. Can alter it. The only precondition is that after altering the charge, all the witnesses which are examined earlier, they will be now recalled and they will be again examined and cross-examined by the parties if the accused so wants. A de novo trial, a fresh trial will start upon alteration of the charge, because earlier accused was charged for another offense. Now court has altered the charge, changed the charge. Then opportunity should be given to the accused to defend himself against this new charge. So that is called de novo trial. DENOVO. Fresh trial. Opportunity will be given to the prosecution to examine its witnesses afresh. Accused will be given opportunity to cross-examine the witnesses afresh. With this condition, charge can be altered or a new charge can be framed at any time before the judgment is pronounced. Recall, cancellation or deletion of charge. Once a charge is framed, it cannot be deleted or recalled or cancelled. It can be altered from one section to other section. 260. I am taking you to another point, 11A. Conviction for charge not framed. A charge was framed against an accused for the offense under section 379 IPC. During the trial, evidence was brought on record that the theft had been committed by the accused from a dwelling house, and a charge for offense under section 380 IPC ought to have been framed, but for mistake, the charge was framed under section 379 of the IPC. The court can exercise its power under section 216 of the CrPC. Now it is 239 in the BNSS, and accused can be convicted for this new charge. तो ये कभी भी हो सकता है. कोई सवाल हो तो पूछो.
Participants.
जजमेंट में चार्ज कब बदल सकते हैं? विदाउट फ्रेमिंग ए न्यू चार्ज. 11C, conviction for charge not framed. Supreme Court says the name of the case is Bharamappa Gogi versus Praveen Murthy, AIR 2016 Supreme Court 791. There are many other cases also. I have noted it here. And Supreme Court says if the accusations were already known to the accused and he had been given sufficient opportunity during trial to defend himself against those accusations, but when the judgment is being written by the court, by the judge finds that the accused deserves to be convicted for a different penal section than the one which was mentioned in the charge framed, then without framing a fresh charge, without exercising the power of the court under section 216 of the CrPC, now under section 239 of the BNSS, court can convict the accused for the charge not framed and may award him the penalty that can be awarded for this new penal section, though a charge was not framed for this. These twin conditions must be satisfied. Otherwise, normally, law is that if the court wants to alter the charge, it must frame a fresh charge by exercising its power under section 216 CrPC, now under BNSS 239. Go for de novo trial, should provide opportunity to prosecution and to the defense to lead their evidence, and only then for this newly framed charge, conviction should be recorded. But if these two preconditions are satisfied, then court need not go for exercising its power under section 216 CrPC. Number one, the accused was aware of the accusations for which he is going to be convicted. Number two, he had been effective charge and its effect. In CrPC there was a section 454. It has now become 510 in BNSS. It provides merely because of some defect in the charge, a conviction would not be bad. The only condition is that the accused was having sufficient opportunity to defend himself and he was aware of the charges, accusations labeled against. 464 of the CrPC has now become 510 in your BNSS. A defective charge, some errors or omissions having occurred in the framing of the charge, or then not the accused was not prejudiced by such error, such omission. If the accused, आवाज मिल रही?
Yes, sir. आ रही
Hello.
है आवाज.
If the accused was not misled by such irregularity, he had occasion to defend himself, then despite some error, omission, irregularity in the charge, his conviction would be proper for such defective or erroneous charge, provided if he knew about the real accusations and he had occasion to defend himself. Your questions, please, if you have any questions you put to seek clarifications, you can. Anybody having any questions?
So the participant is asking about plea bargaining. Is it really practical or it is just in the books?
Yes, it is not binding. If the accused is willing, he can go for it. Unless the parties are willing for it, plea bargaining may not happen. There are conditions 265 to 65A in the IPC, now new penal sections in the BNSS. The provisions are still there. They can go for it. But you know, it is consensual. It cannot be forced on them by court. Whether a new accused can be added during trial and charge can be framed against him, answer is yes. But at the stage of framing of the charge, a new accused cannot be added. He can be added only when section 319 of the CrPC is invoked by the trial court. Means some evidence is collected by the court during the trial, which discloses the involvement of any such person in the commission of the offense who was not charge sheeted, against whom there was no material in the case diary. He can also be summoned and tried by the court. 319 CrPC, for which there is another section in the BNSS now. After collecting the evidence, after summoning that person as an additional accused, charge can be framed against him and he can be tried along with other accused persons against whom charge was already framed and who are already being tried. But remember it that a person who was not charge sheeted, he cannot be proceeded against him, a charge cannot be framed under section 228 of the CrPC or 240 of the CrPC. Charge can be framed only when the court collects some evidence. Some evidence is brought on record during trial showing his involvement in the commission of the act. There are rulings on this point in this article, and I have noted it. You can consult it on my website, lawhelpline.in, and the caption of the file is Charges in Criminal Trials. I would love to answer your queries, please. There are very few queries from your side. I expect more and more queries. Instead of covering the subject on my own, it will be more beneficial to you if you people put your queries, you seek your clarifications. So I think that will be more beneficial to you. And now, in a way, I have completed this subject. I leave the remaining session for you to put your questions, seek clarifications. Please.
Participants, any queries, please, you can post it in the chat box also. Sir, can WhatsApp be admissible as an evidence?
Any conversation made through WhatsApp between two persons or any message having passed from one person to everything is admissible. Section 88A of the Evidence Act, there is a presumption now in Bharatiya Nyaya Sanhita, or that is Bharatiya Saksha Adhiniyam 2023. There is a new section for it, but it is admissible. Any message, any voice of conversation recorded is very much admissible. It is admissible in evidence, provided there are certain preconditions. It must be proved that it is the voice of the person whose voice it is said to be. Number two, there is no tampering in the voice, no interference in the voice. Number three, it is clearly audible. Next, it reflects upon the matter under inquiry, means it must constitute some offense. If it is a criminal case or if it is a civil liability, it must reflect upon the merit of the case. So, subject to these preconditions, proof of these preconditions, conversation, message, everything is admissible. This is electronic evidence, and electronic evidence was admissible in evidence even under the old Indian Evidence Act 1872, and the same is still admissible under Bharatiya Saksha Adhiniyam 2023, very much admissible.
Can a court suo motu discharge an accused?
Why not? If the court finds, if the prosecution does not oppose the discharge, or opposes the discharge. It is not the support or opposition by the prosecution that will lead the court to record the discharge or to frame the charge. The court will be guided, court would be led by the evidence contained in the police report. The public prosecutor appearing for the prosecution will have to point out the evidence in the case diary. If he does not point out, then it is the duty of the court to see whether discharge can be ordered. If the court is satisfied after going through the material in the case diary in the police report, court would discharge the accused, irrespective of the public prosecutor opposes or supports his opposition or his support is not that material. Material is whether the court is satisfied with regard to the material placed before it.
Can we say charge is a part of inquiry?
No, not at all. With the framing of charge, trial commences. If there is the language used by the Supreme Court is that with the framing of charge, I am cautiously using this word. With the framing of charge, trial commences. If the court drops the charge, court discharges the accused, then there is no trial. Then you can say it is inquiry because trial commences only with the framing of the charge. If the charge cannot be framed, the proceeding will end into inquiry. There would be no trial.
What is the defense that can be taken in case when police makes a false charge?
Police submits its report, what is called police report in CrPC 173(2). And in BNSS, there is a new section for it. What is that new section for it? 173. I'm pointing out for one that 173 has now become 193. If the police submits a final report to the court, doesn't submit the charge sheet, it says no case is made out against any accused, and this final report is submitted to the court of the magistrate. What are the options of the magistrate on receiving this final report from the police? Number one, the bounden duty of the magistrate is to issue notice to the informant who had lodged the FIR, informing him that the investigation by the police on his FIR has ended into submission of final report. This informant may come to the court, may file his protest petition, objections against the final report, may request that there is evidence in the case diary in the police report, and on the basis of that evidence in the case diary, accused persons can be summoned. And if the magistrate is satisfied that there is evidence in the case diary and police has wrongly submitted the final report, the magistrate would reject the final report, will summon the accused. Number two, if the magistrate is satisfied that police has rightly submitted the final report, there was no evidence, there is no evidence in the case diary, magistrate may reject the protest petition, may outright accept the final report, may drop the proceeding. Third one is, the magistrate may direct the police for further investigation. Fourth one is, magistrate may treat the protest petition of the informant as complaint and may proceed on it as if it were complaint, and will then observe the procedure provided under section 200 and 202(3)(4) of the CrPC, 200, 202, 203 or 204 in the CrPC, for which the new sections in this BNSS are. I'm pointing out 200 has now become 223, 201 has become 224, 202 has become 225, 204 has become 227. There is a procedure provided in the CrPC now in BNSS in these sections. Magistrate will then follow that procedure provided for complaint case. And if he is satisfied, from a physical case is made out, he will take cognizance, will summon the accused. And if he is not satisfied, he will dismiss the complaint.
So if a person, sorry sir.
Magistrate or court are never bound by the police report. Magistrate or court have to apparently sections into its report. A conclusion reached by the police after investigation into its police report is never binding upon the court. Court can independently apply its mind and go through the evidence contained in the police report, may form its opinion with regard to the making out or non-making out of any prima facie case. So in short, you should know the magistrate or court is never bound by the report of the police.
Sir, is reply to a notice received under section 111 CrPC and 107 IPC mandatory?
It's always option, and if despite notice the person against whom this notice has been issued is not turning up before the executive magistrate, the executive magistrate may proceed against him in accordance with law. If he is likely to breach the peace, may order his detention. Police may register FIR against him in appropriate sections, and if he is likely to commit or has committed any cognizable offense, may even cause his arrest, effect his arrest. So these coercive process may then initiate. Otherwise, normally it is for the person who has been issued the notice to respond to the notice. He can choose not to respond only at his risk.
Sir, if a accused is not allowed to present evidence, then how is there equality before law?
If accused wants to produce certain evidence in his defense and he is not allowed, then trial stands vitiated on challenge before the superior court in revision under 482 CrPC in CR and under new section now 528. Proceeding would be quashed. It is unfair trial because an accused has got every right for a fair trial. Fair trial means providing opportunity to the prosecution and to the accused both to lead their evidence. Court cannot prohibit the accused from leading his evidence in his defense because the fairness and fair play is the core of our justice system, and denying opportunity to the accused to produce evidence in his defense destroys the entire fairness of the trial, and the trial would stand vitiated. Proceeding would be quashed. Yes.
Okay, sir. So last question, any tips on how one can master BNSS because it's very confusing?
No, nothing. Nothing is confusing. It will take a few months to judges, magistrates, lawyers, everybody who is connected with this new law. You just see are the sections in the CrPC, for the sections in the IPC, for the sections in the Indian Evidence Act. There are now new sections in BNS, Bharatiya Nyaya Sanhita, BNSS, Bharatiya Nagarik Suraksha Sanhita, and Bharatiya Sakshya Adhiniyam. It will take some time to memorize these sections. That's the only problem. The advice to people is they should consult the table given in the beginning of these new laws. What was the old section and what is the new section in new law for old sections? In certain new sections, some new provisions have been added, but most of the laws are the same. Whether it is IPC, whether it is CrPC, whether it is this new Bharatiya Sakshya. In Sakshya Adhiniyam, very little changes have been made. Changes have been, in fact, been made in IPC, this Bharatiya Sakshya, Bharatiya Nyaya Sanhita and Bharatiya Nagarik Suraksha Sanhita. In Evidence Act, no fundamental changes have been made. Only sections have been displaced from here to there. So that's not a difficult area, difficult thing. Courts are functioning, magistrates, judges, lawyers, everybody has started functioning under this new laws. So I don't see any reason people are feeling difficulty. Initially, you can say there is some teething trouble because many people are not used to the new laws. But with the passage of time, gradually they will come, and every person who is a practicing professional, a lawyer, judges or magistrate, they are duty bound to be familiar with this law. Otherwise, how will they work? How will the system work? Even police walas, they are being given training in all the states. Even before July 1st, in all states, police personnel had been given training in their states. Now they are efficiently dealing with these new laws. So is the case with the magistrates, with the judges, and there would be no difficulty. It is just a few months from now when people will become efficient and familiar with these laws and will start working efficiently and smoothly. Yes.
Okay, sir. We are done with the queries.
All right. Thank you.
So thank you so much, sir. इतना हमें clarity देने के लिए बहुत in-depth explanation था. Thank you so much.